Thanks. It's great to be here. I love how interdisciplinary the Health Law Center conferences are. So it's exciting to talk to a variety of people. Our topic is going to be pretty legal, but I think we'll keep it a high level enough that it should be interesting to everybody. We came to this topic in a kind of a funny way. In that my background is actually in corporate crime and sort of philosophical foundations of corporate crime. I'm not a mental health lawyer at all, but I've done some stuff on law and emotions, corporate emotions actually. So when Jen and Sophie were putting together the contributors for this book, Jen asked me if I wanted to do something on law and emotions with respect to the designation of not criminally responsible by reason of mental disorder. And I said, oh, sure, that sounds interesting. Not sort of pausing for a minute to think like, well, this is not the work that I do. But anyway, then I wrote in Anoosheh, who's my brilliant RA. And we thought at first, so there's this case, Minassian, that Anoosheh will tell you a bit more about in a bit, but that's sort of opened the door to finding that somebody could be not criminally responsible in virtue of being autistic and having low theory of mind and low emotional cognition. So not being, having what you might think of as a deficiency in understanding other people's interior lives. And I guess at first I sort of thought, well, would we want to think about expanding the definition of NCRMD to include that? That isn't where we landed for a few reasons. But a big one is that the designation of NCRMD is what colloquially gets called the insanity defense. So when I say that, you can think the insanity defense, if that helps. But that NCRMD is sort of sensationalized in the media a lot as being like a get out of jail free card, like somebody does something really serious, their lawyers go and they say this person was, suffering from delusions, and then they're released the next day. But in fact, what happens when somebody's found to be NCRMD is they're held usually indefinitely. They're incarcerated in a hospital setting, but nevertheless sort of, incarcerated for as long as the experts decide they should be, right? So it can often be a much worse result than getting a criminal conviction, which is why it's usually not argued, at least not by the defense, except in really serious cases. So that broadening NCRMD is not necessarily where you want to head. So anyway, we're going to talk today a little bit about Minassian and this idea of emotional cognition and why we don't think that it should fit the NCRMD result. And then Anoosheh will hand it back to me, and I'm going to talk a little bit about another very recent case from the Ontario Court of Justice that's currently still under appeal at the Ontario Court of Appeal, called Warren, and why we think that could kind of give us a path forward outside of NCRMD, but for maybe having a kind of not solution. None of these solutions are ever very good when you're dealing within the kind of the current prison system, but a third way that might be an improvement over current practices for incarcerating people with mental health difficulties. So that's what we're going to do today.
Okay, so I guess I'll start from the foundational principle in criminal law that the stigma of criminal responsibility is attributed only to those offenders whose actions are a product of their free and voluntary will. And this sort of reflects the idea that the criminal law views individuals as autonomous and rational beings. So the criminal code recognizes this in section 16 of the criminal code, and specifically in this context, it recognizes this through the NCRMD designation, the not criminally responsible due to mental disorder. So there are two main components to this provision. So the first is hurdle, or I say hurdle, but it's a pretty broad category. So it's pretty likely that something will be categorized as a mental disorder within this definition. But the first hurdle is that the offender must be suffering from a mental disorder. The second sort of hurdle are the two branches of the test. So that's first, that they are incapable of appreciating the nature and quality of the act or omission by reason of the mental disorder. And then the second one is that it's an either or, that they knew that it was wrong while they were committing it, and this is again by reason of their mental. Does not result in an acquittal, but instead results in a designation of NCR. And so that means that it triggers an administrative process, which essentially is designed to think about whether there is a significant threat to society in that individual, in that offender being released. And if so, then thinking about what treatment options are possible and how the system can best control that threat. So there are some concerns, I guess, with the NCR designation. And scholars in this area have written often about how under-inclusive the regime can be. So the first work that our paper sort of cites is that of Benjamin Berger's, and that's essentially in, I guess, the conditions that the defense recognizes, not through the mental disorder branch of the test, but in the threshold that it would have to reach in order to meet one of the other requirements. So an example that Berger provides is the fetal alcohol syndrome disorder, as well as Asperger's or ASD, autism spectrum disorder. And those are thought of as conditions that would disrupt or at least raise some concerns in terms of how we attribute criminal responsibility, but that nonetheless don't meet this sort of acute threshold that is imagined by this sort of law of mental disorder. And so often with this threshold, we see that in the case law, at least, we see this manifested through some of the successful examples of NCR we see are mainly individuals who experience some level of delusions while they're committing the act. So a popular high-profile sort of example of this is Vincent Lee, who was responsible for the 2008 Greyhound bus murder of Tim McLean. In that case, for example, the accused was said to have heard voices from God telling him to commit this action or commit the murder, essentially, or that he would himself be killed by God. The second sort of concern that we have with this, and I think Professor Rich sort of alluded to this, is that we might not really see this as an effective means or something that we'd want to be championing anyways, because of some of the concerns that we have with prolonged or sometimes or potentially indeterminate sentences that are facilitated through this regime. And so this is why the case of Minassian becomes quite a bit of a development in this area. So Minassian, if you're sort of familiar with this, is the 2018 case. Minassian had rented a van and drove it into a crowded pathway in Toronto, killing 11 and injuring several others. So Minassian had described himself as an incel to the police and had made several social media posts describing the attacks as a continuation of the incel rebellion that had started 4 years prior with the Isla Vista killings in 2014 in the US, by Elliot Rogers, who was sort of the face of the incel movement at the time. Additionally, Minassian had been diagnosed from a young age with autism spectrum disorder, and so this sort of becomes a key part of the case in determining whether or not Mr. Minassian is eligible for the defense of NCR. So getting a little bit into the reasoning of Justice Molle, with respect to whether ASD qualifies as a mental disorder, Justice Molle confirmed that ASD met that criteria, but specified that this qualification simply opened the door, but it didn't do more in terms of proving definitively that this was a defense, a total defense to the charge. It further did not say anything about the connection between ASD and criminality, which is another thing that we sort of touch on in the paper, that ASD is not a condition that is, by virtue of its symptoms or effects, is not entirely crimogenic or not entirely susceptible to leading to, crime or criminality, perhaps. So with respect to the assessment of how ASD had impacted Minassian's life, Justice Molloy found that he had significant deficits as a result of ASD, particularly in the social communication, areas of social communication, his ability to understand emotions and perspectives of others, and his ability to feel empathy. However, the court found that because he was of above average intellect, he was able to use his intellect to overcome some of those impairments that we would typically see resulting in a different scenario otherwise. So with respect to branch 2A, so that's the incapable of appreciation branch, Justice Molloy determined that, and relying on expert reports, that Minassian was not suffering from any delusions at the time of the attack, and nor was he psychotic. And he was aware that he was driving the car down a pathway, hitting people and resulting in their death, which was irreversible. With respect to branch 2B, the knowing it was wrong branch, Justice Molloy concluded also that Minassian knew his actions were legally wrong because he understood that his deliberate killing would constitute a criminal offense. So the issue of the case therefore became whether Minassian knew that his actions were morally wrong. And here it was critical to sort of underscore that the case law on this point states that an accused cannot be said to understand or know that something is morally wrong if, as a result of their mental disorder, they lack the capacity for rational choice or for choosing between a right and a wrong decision. So ultimately, Justice Molloy found that Minassian knew his actions to be morally wrong. In pointing to this conclusion, Justice Molloy pointed that Minassian knew that the vast majority of people in society would find that an act of mass murder would be morally wrong, but that the overarching concern, his overarching concern of wanting to achieve fame or notoriety from this killing was really what I guess trumped or surpassed his ability to tell that it was a wrong action. Using reports from past therapists and psychotherapists, there was evidence that he had been fantasizing about a crime such as this one for almost a decade. He had described his own actions as morally terrible, and that found that even if Minassian had only relied on his intellect and not his capacity for emotions to come to that conclusion, that it nonetheless was sufficient because it demonstrated that he had a rational and functioning brain. So essentially, Minassian was capable of choosing between right and wrong, and he nonetheless chose to commit the reprehensible acts anyway. And so on this finding, Minassian was said to not have met the NCR test or defense and was thus held criminally responsible on all charges. So where did this leave us? So the Minassian case to an extent rejects this idea that emotional impairment renders someone incapable of making a reasoned, rational choice, at least in the context of the NCR regime. But to some extent, and this is sort of based off of research that is outside of the NCR regime and outside of how empathy, the value that empathy has in the NCR regime, we disagree with this. And so there's a section in the chapter where we briefly develop this idea that through some more legal philosophical research, but also looking at some studies that describe, for example, how impaired theory of the mind, specifically in the context of ASD, may contribute to, for example, the disruption of one's capacity to read social cues, evaluate emotional reactions, foresee consequences, and engage in problem solving. And so for us, this was something that would bear some relevance. And while we think it might not completely attenuate criminal responsibility, we think the law should account for it. So this is sort of a complex position where we sort of have to acknowledge that emotional defects have some impact on moral judgment and decision-making, and that beyond this, all sorts of mental health conditions can have the same impact. So we find that the law doesn't properly account for this. It has a hard time doing that because it tends to be quite binary. So it's either you are NCR or you are not, you have a mental disorder or you do not by the standards of this regime. And so, as Professor Rich mentioned, we're not sort of proposing a spectrum, but we are proposing this third midway point. And with that, I'll pass it on.
Great, yeah, so, yeah, so we were sort of left in this, I guess, kind of quandary with Minassian, that it didn't seem like he should fit into the narrow definition of NCRMD, and it wasn't clear to us that there was good reason for advocating to expand NCRMD again, because it's not really beneficial, often has downsides for, at least other than for very serious offenses. And somebody pointed us to the case of Warren, which is a really recent case. This case is actually currently under appeal at the Ontario Court of Appeal. It was decided by Renee Pomerantz, who's now actually at the Ontario Court of Appeal. Obviously, she won't sit on the appeal, but there's a lot of judges there, so somebody else will sit on it. But I think there's, a decent chance it'll be overturned. But it's a super interesting case because it's not an NCRMD case. It's a case in which this man was being prosecuted for having set a fire, and the Crown was seeking to have him designated as a dangerous offender, one of the results of which is that you could be held indefinitely in prison. Why? Well, okay, so this man, Warren, his story is really tough and really tragic. He was a victim from a very young age of sexual and physical abuse, mostly by his father, but also by other family members and other people. At the age of 6, started trying to commit suicide. Was just a really the really heartrending story. And also, in the last panel, Archie talked about intersectionality and how people with intellectual disabilities often will be people with mental health disorders, and who knows about the kind of whether the causality can go one way or the other. But this person was also in the bottom 1% for IQ. So a person with sort of limited intellectual capacity, maybe, right? And he was a really sad guy and didn't have a support system, and he would set fires, and he liked setting fires to buildings. He would always tell somebody. So he would set a fire out of frustration, or when his trauma got too much and when his anger got too much, he would set a fire, and then he would go tell somebody, building's on fire, and building would get evacuated, or he'd turn himself into the police and he'd say, look, I've done this thing. Nobody ever died, but obviously you realize there's a bit of a luck element there, right? Because these are dangerous things he's doing, and even though he's taking responsibility for them right away after, you sort of can't feel like, oh, this is okay, let's let this continue, right? So Justice Pomerantz was sort of faced with this dilemma of there's a lot of reason to feel a lot of empathy for this guy, but at the same time, she has to agree that legally he does fit the dangerous offender designation, right? This guy is probably an ongoing danger to society. This is a pattern of setting fires, big fires. So she says, yeah, I have to accept that this guy probably shouldn't just be released in 3 years or even 5 years, right? But she then said, I hate, she didn't say I hate the idea, but there was something really problematic about saying, let's just put this guy in prison for basically what's going to be the rest of his life, right? And some of the reasons why that, she sort of had brought to bear a lot of evidence here on why this guy shouldn't be in prison for the rest of his life, because he had been in prison before, and when he was in prison before, because of his low intellectual capacity, because of his trauma, because of his mental, issues, was victimized a lot by the other inmates, and so spent a lot of time in solitary confinement, which again is torture under the UN definition, for extended periods of time for his own protection, sometimes by his own, asking to be put there because he was being victimized, and also wasn't able to participate in a lot of the programming that might be available in prison, because when you're in solitary, you can't, but even when he wasn't in solitary, he just didn't have the intellectual profile to be able to do some of the things that were being offered, so he was left out. And so she said, look, there's evidence that this is what happened in the past. This is what's going to happen again, and it's going to happen for the rest of his life. There's going to be no hope for this guy to be rehabilitated. And so what Justice Pomerantz did was she found a Section 12 violation. Section 12 of the Charter protects against cruel and unusual punishment, and there's a recent-ish case from the Supreme Court in our view, Sonnet, that sort of enshrined the idea that hope is a principle that should be allowed to, everybody should have hope that they could one day be released. And so she found that de facto, because of the way that incarceration was going to go for this man, he was going to be denied any hope of ever possibly rehabilitating, because he was just going to be consigned to this horrible fate of just, constantly being victimized and being in solitary confinement and not being helped. So what she did was she ordered a charter remedy. So Charter Section 24 says you can order a remedy if somebody's charter rights are being violated. So she found an anticipatory violation of his rights, and then she said, and to remedy that violation, I'm ordering for this man to be transferred to a provincial hospital, to a mental health facility. And she'd also heard some evidence from some psychiatrists that provincial hospitals give better psychiatric care than prison hospitals, which are much more focused on security rather than on therapy. And so she ordered for him to be transferred there for the duration of his indefinite confinement, and she wanted yearly reports back to the court, which is also an interesting feature of the case. And they've been doing this, and I have it from an unofficial source of a clerk at the Ontario Court of Appeal, that she's still getting the reports, even though she's now at a different court. They're still sending them to her personally. So, there's anyway, it's an interesting case to watch, and I think it'll be really interesting to see what the Ontario Court of Appeal does. But anyway, what it did for us was to sort of give us the idea that maybe there's a third way. So maybe, including maybe for somebody like Minassian, or at any rate for people with significant mental health difficulties who are nonetheless going to be found guilty of crimes, that there are perhaps reasons to say, well, we're not going to order NCRMD, we're not going to broaden NCRMD to capture all these cases and put everybody in indefinite detention, but they could serve their definite sentences, they could serve their periods of incarceration in a hospital rather than in a prison. And of course, in the last hour, we heard all sorts of stuff that makes me want to rethink, because I'm like, oh, babe, the hospitals are really not as great as, you might have thought they are. And of course, that's true. And, like I said at the start, there's no great solutions in this area where you're dealing with incarceration of people who are largely embroiled with the criminal law system because of tragedy in their lives. You know what I mean? Like these are just hard stories. And so I'm not saying that this is a perfect solution, but I think it might present a slightly better alternative. And what I found really interesting after having read, and I read Warren as a criminal law person with like a lot of like, wow, this is like groundbreaking stuff. But then she points to an article that led me to this Law Reform Commission of Canada report from 1976, suggesting that the government do this legislatively and just have hospital transfers where appropriate for people who, need to be in hospital rather than in prison. I know I'm running out of time. I thought I'd be way under time, but anyway, that's never how it works out. But I just wanted to mention briefly that, Justice Pomerantz ordered this as a charter remedy. That's like a kind of bespoke sort of thing. But if it was done legislatively, it could be done with a much sort of bigger, more comprehensive kind of set of criteria, or safeguards, whatever, that could make this into like a pretty maybe decent third option for people with significant mental health difficulties. And potentially one of the reasons to argue in favor of spurring the government to do this, I think there's probably a pretty good argument that people with mental health difficulties are being discriminated against in prison as it currently stands. So there's probably a Section 15 equality argument that there's a Section 15 violation going on here in prisons. I mean, shocker, but nonetheless, maybe a reason in favor of remedying that by giving equal treatment to people with mental health issues by putting them in a setting that is more therapeutically appropriate for them. So yeah, anyway, this is, as I said, not really my area of expertise, not really Anoosheh's areas of expertise. So we would love to hear if anybody has like suggestions or disagreements or things that we need to read before we finalize this chapter. Please get at us, and that would be great. And yeah, thanks.
Good morning. Is this on? No? How does one make it go on? No? Off? On? Okay. Well, just thank you very much, first of all, to the organizers for putting together this really very interesting and valuable conference, and compliment the organizers on their anti-ageism, which is demonstrated by inviting the geriatric likes of myself and Archie to a conference of this sort. I truly appreciate it, because at some point you start to worry that you're going to be, out of the action and missing out on things. So thank you very much for all of that. Thank you for the last great talk. I understand that there may be people from the Law Commission, or whatever the new iteration of the Law Reform Commission is. And without getting into it too deeply, it might be time, with the sort of conundrum that was faced by Justice Pomerantz, to think again about the concept of diminished responsibility, which is a halfway point, not necessarily a halfway point, but it recognizes that mental disorder, which drives criminal responsibility, is a sliding scale. It's not, as the previous presenters indicated, not a dichotomous one. You're either fully responsible or not responsible. Anyway, just a thought before I move into what I wanted to say. I retired from the court after 25 years a year ago, and I still do sit per diem, but I want to make it very clear that the comments I'm making today should in no way be taken as representing the views of the Ontario Court of Justice. As you'll see, I'm quite critical of a lot of things, and I wouldn't want anyone to walk away with the idea that I was representing the court. It's basically what I'm doing here is an update on the high-risk accused legislation. The, quote, tough on crime legislation resulting in the potential for mentally ill accused to be designated high risk came with Bill C-54, the, quote, Not Criminally Responsible Reform Act, which was introduced in February of 2012 and came into effect in July of 2014. I was just saying to Jennifer, I'm not too sure with all of my notes where I'm going to land and when I'm going to get the hook. So I'm going to start with where I wanted to end, and that is to note that built into Bill C-54 was a mandatory 5-year review, which I tried to find it, and perhaps there are people here that are much better at that sort of thing than I am, but to the best of my knowledge, that has never been undertaken. So, the bill's most controversial amendment was this new designation of high-risk accused, or HRA. The designation carries with it the potential for an accused found not criminally responsible, or I'm sure you're familiar with it by now, NCR, on account of mental disorder, to be hospitalized without review, if they consent, for up to 3 years, whether or not hospitalization is clinically indicated. The cases highlighted as the impetus for this tough on mentally disordered accused legislation were, we just heard in the last panel, those of Vincent Lee, who decapitated and cannibalized a passenger on a Greyhound bus while in a psychotic state, and Alan Schonborn and Guy Turcotte, who both murdered their children while in psychotic states. What was apparently missed by the politicians and the legislators was the fact that the few high-profile cases which were the impetus for the bill were, at the time of their criminal acts, not part of the scheme sought to be changed. Therefore, it cannot be said that criminal code deficiencies were in any way responsible for these very unfortunate events. Nevertheless, Bill C-54 created a scheme where mentally ill individuals obtaining NCR verdicts may be incarcerated in a forensic hospital bed for up to 3 years without review. This is, I was speaking to somebody at the break. I take great comfort in that I suspect I'm largely here preaching to the choir. This is counter-therapeutic, very expensive, and an unnecessary infringement upon the liberty of the accused. Further, and importantly, it is inevitable that many accused who might otherwise have considered a defense of NCR might now do everything they can to avoid such a verdict because of the potentially disproportionate consequences that have been elevated even more with the potential for an HR designation, which admittedly is being used very rarely. When this occurs, that is when one avoids the path of NCR because of this concern, when this occurs, these accused will end up in the regular prosecutorial stream, and from there, if convicted, these accused will end up in the regular, they'll end up in the prisons. One day, these individuals will be released from jail onto the street and not properly supervised, and this, of course, is a very dangerous situation. So with Bill C-54, although there had been previous rumblings, the story officially broke in the fall of 2012 in the National Post. In the name of victims' rights and as part of the federal government's tough on crime agenda, we heard that changes would be made to Part 20.1 of the Criminal Code. That's the little mini code within the big code that deals with how we should be handling mentally disordered accused. That part of the code that deals with mentally disordered accused. Since Bill C-30 came into force in 1992, Bill C-30 was what gave birth to Part 20.1, it is basic that accused who have obtained a verdict of NCR are reviewed not less than annually. And so long as the statutory jurisdictional thresholds are met, the provincial or territorial review board must determine and impose annually the, quote, least onerous and least restrictive disposition after taking into consideration, 1, the need to protect the public from dangerous persons, 2, the mental condition of the accused, 3, the reintegration of the accused into society, and 4, the other needs of the accused. This is how the legislation read prior to the proclamation of Bill C-54. As set out in Part 20.1, as it then was, dispositions may vary between a requirement that the accused be housed in a maximum security psychiatric hospital with no access to the community, to one where the accused is living in the community with very few restrictions upon their liberty, much as they might do if they had a probation order or a judicial interim release order. In November 27th, 2012 National Post article, Justice Rob Nicholson was quoted as saying, quote, "We are listening to victims, as well as the provinces and the territories, who are telling us that the safety of the public should be the paramount consideration in the decision-making process involving mentally disordered persons." Well, this was not really controversial and arguably redundant or worse, in that the courts of appeal and the Supreme Court of Canada, for example, in Pinette, have made that priority abundantly clear. As the court in Pinette said, the objective is to reconcile the twin goals of public safety and treatment. In this process of reconciliation, public safety is paramount. So that amendment really added nothing. In the National Post article, statistics were provided which revealed that recidivism rates for individuals subject to the jurisdiction of the review boards were within the 3 to 7% range, whereas for individuals within the parole system, recidivism rates were approximately double, and for those who had simply completed a prison sentence, the rates were 5 times as great. So we argued on the basis of these statistics that the safest place for an accused to be is within the review board system, subject to the current provisions of Part 20.1. Incidentally, the research project which generated these numbers was one funded by the Federal Department of Justice. So nevertheless, we have Bill C-54 come into effect, and rewrote section 672.54 of the Criminal Code, which is most of you, I'm sure, are familiar, the disposition-making section of the code. And I'm going to leave out little section numbers and specific case references and statutory references. They're all in the book chapter that I wrote for this project. When a court or review board makes a disposition, it shall, taking into account the safety of the public, which is the paramount consideration, this is the new version, the mental condition of the accused, the reintegration of the accused into society, and the other needs of the accused, make one of the following dispositions that is, quote, necessary and appropriate in the circumstances. So we have public safety underscored as the paramount consideration, and we have least onerous and least restrictive replaced with necessary and appropriate, which I'm not going to deal with that. I deal with it in the chapter. Interesting, necessary and appropriate is obviously conjunctive. One wonders when something will be necessary but not appropriate, or appropriate and not necessary. Anyway, that's another rabbit hole that I'm not going to get into here. As I indicated earlier, this amendment was not really controversial and arguably redundant. And the most controversial amendment, that pertaining to high-risk accused. The provisions creating the HRA, high-risk accused designation, the new designation sounds eerily like a DO for the mentally ill. The dangerous offenders provisions that are contained in Part 29 of the code. Anyway, the new test, or the new HR provision, is essentially this, and it's contained in, I hate reading statutes, but it's unavoidable here, 672.64, an application made by the prosecutor before any disposition to discharge an accused, absolutely. The court may, at the conclusion of a hearing, find the accused to be a high-risk accused if the accused has been found not criminally responsible on account of mental disorder for a serious personal injury offense. Serious personal injury offense is defined, and it means an indictable offense involving one, the use or attempted use of violence against another person, or two, conduct endangering or likely to endanger the life or safety of another person, or inflicting or likely to inflict severe psychological damage upon another person. And the court is satisfied that there is a substantial likelihood that the accused will use violence that could endanger the life or safety of another person, or B, the court is of the opinion that the acts that constitute the offense were of such a brutal nature as to indicate a risk of grave physical or psychological harm to another person. So the HRA designation requires two things: a serious personal injury offense, and two, either substantial likelihood of violence or risk of grave physical or psychological harm to another person. And the provisions go on to suggest inter alia considerations that might be had in order to make the determination, the nature and circumstances of the offense, any pattern of repetitive behavior of which the offense forms a part, the accused's current mental condition, the past and expected course of the accused's treatment, including the accused's willingness to follow treatment, and the opinions of experts who have examined the accused. If the court finds that the accused to be a high-risk accused, the court shall make a disposition, mandatory, under 672.54C, but the accused detention must not be subject to any condition that would permit the accused to be absent from the hospital unless it is appropriate in the opinion of the person in charge of the hospital for the accused to be absent from the hospital for medical reasons or for any purpose that is necessary for the accused's treatment. if the accused is escorted by a person who is authorized by the person in charge of the hospital, and a structured plan has been prepared to address any risk related to the accused's absence, and as a result, that absence will not present any undue risk to the public. So just again, a recap, the application may only be brought by the prosecutor before a court. The discretion to impose such a designation is entirely out of the hands of the review boards and placed into the hands of the court. Which court? A review goes to the Superior Court. This is presumably because Parliament did not want a lower court being able to review the decision of a Superior Court. When, before any disposition to discharge an accused has been made. And what does this mean? It probably means anybody who was in the system at the time the legislation came into effect was fair game. As mentioned, these provisions are arguably an attempt to bring in something akin to dangerous offender status for the unconvicted mentally ill accused. There was no data to suggest that the previous scheme did not already adequately handle accused at the more extreme ends of the continuum. And the provision with respect to less frequent review. Now, this is curious. This would appear to make no clinical sense. By way of analogy and rhetorical question, if you have a pot in the kitchen which you think might boil over, do you check in on it more frequently or less frequently? With the previous scheme, accused who satisfy these criteria would have very likely been obtaining very restrictive dispositions in any event. So what the HRA designation appears to be doing is making mandatory what the review boards would generally do on their own in any event. Again, adding nothing, but arguably worse than adding nothing. As I mentioned earlier, the poster boys for this tough on mentally disordered accused bill were Vincent Lee, who we described before, Alan Schonborn, and Guy Turcotte. The proponents of the bill had taken extremely horrific outlier cases involving people who committed their offenses prior to obtaining verdicts of NCR and entering the review board system as oblique indictments on the provisions of Part 20.1, which govern them after the verdict is obtained. However, these examples are more appropriately indictments. If indictments are to be made, they're more appropriately indictments upon the civil mental health system, which failed to contain dangerous individuals, rather than upon the review board system, which they were not yet a part of. There are approximately 5,000 review board dispositions rendered in Canada annually, and typically you can count on the fingers of one hand the number of significant problems with those accused. As mentioned earlier, at least in terms of recidivism, the safest place for an offender to be in Canada is subject to the jurisdiction of a provincial or territorial review board. Further implications, certainly in Ontario and most other parts of Canada, hospital beds for review board patients are in very short supply. The Bill C-54 amendments will inevitably result in accused who, from a clinical psychiatric perspective, do not need to be in a hospital bed, occupying one just because of the statutory requirement. This would then constipate even further the flow through of mentally disordered accused into therapeutically optimal accommodation. If the provisions were to be deployed widely, it would cause extreme slowdowns at the entrance door to the system immediately upon a verdict of NCR. The provisions are punitive rather than therapeutic. But more importantly, the amendments will result in contraindicated dispositions that are not the least onerous and least restrictive, taking into consideration the provisions of Section 5.4. The provisions bump into previous decisions of the Supreme Court. as Chief Justice McLaughlin indicated in Winco, quote, by creating an assessment treatment alternative for the mentally ill offender to supplant the traditional criminal law conviction acquittal dichotomy, Parliament has signaled that the NCR accused is to be treated with the utmost dignity and afforded the utmost liberty compatible with his or her situation. The NCR accused is not to be punished, nor is the NCR accused to languish in custody at the pleasure of the Lieutenant Governor, as once was the case, which is what you'll have if you have an HRA accused occupying a hospital bed where there's absolutely no clinical sense to it. A bit about proportionality, which to my mind, embedded within the amendments is quite obviously a rather primitive notion of proportionality. Proportionality is the fundamental sentencing principle as articulated in section 718 of the Criminal Code, which specifies that a sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. But Part 20.1 is not about sentencing, as we are again instructed by Chief Justice McLaughlin, who says, it is well recognized that there is at best a very loose correlation between the nature of the index offense and the disposition that is imposed. All dispositions are driven by the provisions of section 672.54. It might well be that someone who has committed a homicide is quite safe living in the community, whereas someone who has committed a shoplift is so dangerous that they must be kept in a secure hospital bed. Proportionality does not factor into the disposition mix within Part 20.1 of the Criminal Code. Part 20.1, treatment, not incarceration, is necessary to stabilize the mental condition of dangerous NCR accused and reduce the threat to public safety created by that condition. 3 minutes to go. I'm just going to skip along here, I'm sorry. There are problems I'm just going to identify with respect to the reverse onus provisions inherent in the HRA provisions. It's up to the accused if they're looking for the exit ramp to demonstrate that they're no longer an HRA candidate rather than keeping the onus on the state for them to show that they continue or they remain an HRA accused. Retrospectivity, well, again, it's common that typically one would expect that the law in place at the time of the commission of the otherwise criminal act would be the law that pertained. This is apparently, well, there's some case law in point which I've identified. They've dispensed with that. The ironies are that, for reasons that I explain more fully in my written material, the provisions will arguably not apply to most NCR accused. To become an HRA, you need two things: serious personal injury offense and either of the two criteria that I indicated before. But if you take a close look, it is arguable that if Messrs. Lee, Schunborn, and Turcotte were subject to applications to have them declared HRAs with the amendments as proposed, none of them should have succeeded. The worst irony, though, to my mind, is that this legislation, which was sold as something to keep the streets and communities safer, may, to the extent that the HRA applications proceed, which, and again, I have to be fair, have been limited, although I learned from my friend Anita that they are apparently taking off in Quebec for reasons that I think I know the answer to, which we might deal with during question period. But to the extent that the HRA provisions alarm prospective NCR verdicts and spook the bar so that they steer their clients away from these verdicts, as they had done in the pre-Swain, pre-Part 20 point era. To that extent, the legislation, ironically, will leave the streets and communities not more safe, but less safe. And to my mind, that is indeed a grand irony. I apologize for sort of flipping there at the end, but I'm coming to my time, I think, exactly. But I will come back to just remind everybody that if anyone's in a position to nudge, this 5-year review has not happened, and I think there's good reason for it to occur. Thank you very much for your attention.
Hello, everybody. Okay, so I have something a little bit different for you. I'm going to be anticipatory. So I want to talk about a potential treatment modality that's in active development in psychiatry generally, but also specifically for forensic psychiatry. In other words, to interact with people who have mental health problems, mental disorders in the criminal justice system. So to my knowledge, there's not a lot of use of this technique going on yet, but there's an awful lot of research and a lot of ideas. And I think what I want to do with you is to give you just a quick overview of some of the avenues of research, but then to raise what I think are some really interesting legal issues that are posed by that particular form of treatment. So that's basically what I'm trying to do here. And you can kind of see that I'm a little bit between two panels. I'm talking about forensics and so criminal justice. So I'm on the criminal justice panel. I'm not talking about something that's happening right now. I'm sort of a little bit, I've got one foot over in a panel this afternoon, which is about emerging potential psychiatric treatments. So I'm sort of anticipating where you're going to go this afternoon as well. Okay, so let's get started. I think there's some sort of little thingy here which might work. Let's try it. Okay. We always point here, but I bet the sensor's over here. Okay. All right, good. Okay, so what are we talking about? I guess how many of you have tried a VR headset? Not saying, I don't know. I'm guessing like there's always a few lurkers who did but don't put up their hands. So I'm going to guess quarter of you. So I've tried one myself, an Oculus Rift, a really old one, not a very fancy thing, and it was kind of fun. I was flying around in Google Maps around the globe and things like that. So I have that experience with that interesting thing that happens where you have to kind of suspend disbelief, but you kind of come to be immersed, to feel a sense of presence, to inhabit this space, which is sort of obviously not real. I mean, although as AI continues and as our abilities to adjust what you're seeing proceed, it becomes increasingly more real. But anyway, so what we're talking about here is a headset which generates a computer-generated simulation, which is presented to you through this headset. It has a perception of being sort of 360. You turn around and you see the space. You can actually see yourself as an avatar, and some forms of these actually have sort of elements mounted onto your body so that your avatar moves exactly with your own kinesthetic sense of your own body. And so it can be just visual, it can fold in auditory, tactile or haptic feedback, olfactory stimuli. So all of these sensory modalities adding up together to a more immersive, a more persuasive kind of experience. And so in this VR, they talk about presence, which is the sense of inhabiting this space, and not the real space, but inhabiting this presented artificial space. The immersiveness, the extent to which you shut out awareness of the real and come to be inhabiting, in a real sense, the artificial. And embodiment, the sense that your body, your spatial space of your body is felt to be within the virtual reality, and you come to embody the avatar itself. So all of this presents a form of realism, which is being capitalized upon in many ways to treat a range of health problems. People with pain, people with body dysmorphic disorders can be presented with a different version of their own body. There's a lot of evidence too that people respond once they get into this immersive kind of present state. They respond physiologically. So a threat to like the avatar's hand generates a stress response, a physiological sort of adrenaline response that would be consistent with what you see in real life. So this is evidence of this sort of funny space between the real and the virtual, where the body comes to, and the mind comes to perceive this in some sense as real. So what are the advantages of doing this? Well, there's a lot of interesting things that can be done here. So it's a controlled environment. So people, for example, can be presented with severe stressors that might be actually dangerous to produce in real life and can have desensitization, exposure therapies. It's, as I said, safer, but you're not putting people at real risk to confront fears of certain risks. There's a realism to it as well. So if you're trying to, for example, in the forensic context, evaluate someone's symptoms, you rely upon them to remember, to be willing to tell you what the symptoms are. Typically, this is done by interview. This is being done by psychometric tests, this is observing of behavior. But often an observation is done in an artificial laboratory or clinical setting. It's, you know, VR is not real, but it's more real life. It has more ecological validity, as they say, to observe people within this format than in this very constrained sort of environment. So, you know, there's this realism and, yeah, okay, so you can sort of see the advantages here. So lots of therapeutic applications, exposure-based therapy, cognitive and behavioral skills training of different types. We talked earlier about deficits in theory of mind and deficits in recognition of emotion. These kinds of things can be trained and practiced in these environments, although some might say it's better to practice with real people, sure, but this provides also another alternative where it's hard to do the in-person practicing of going into a supermarket and interacting with people. Avatar therapy is also very interesting. I'll come back to this later, but this is for psychotic disorders where people, for example, might have auditory hallucinations, and allows people to confront their auditory harasser or persecutor. And voiced by the therapist can gradually sort of subtly give way, can take over the hallucinated voice and generate statements, responses that allow the person to interact with the persecutor in a persecuting voice and to change that narrative. That's the theory and the hope. And of course, forensic treatment and rehabilitation. So lots of potential assessment applications of real-time behavioral, emotional, cognitive, physiological responses can be looked at in the virtual environment. You can detect malingered or underreported symptoms, measure the intensity of symptoms, do functional capacity assessments, and forensic risk assessment. Okay, I'm going to tell you now a couple of slides of some of the lines of research that are going on. Whoops, wrong direction. Okay, there we go. Okay, there is something called the VRAPT, or the Virtual Reality Aggression Prevention Training. You can sort of see the image. Not super real, but you know, if people suspend disbelief and get into it, it can acquire some sort of aspects of realism. And those of you who've been in VR will know that kind of suspension of disbelief and entering into the world that you feel there. So what happens, people are introduced to the scenario, how it's going to work. They are then given the opportunity to try to assess and discern the emotions of others in the space and to practice self-management of physiological response as a way of there's lots of theory behind this about how violent behavior happens, and it's trying to address an inability to properly identify the emotional expressions of others, which is thought to generate aggressive response by over-identifying angry or aggressive faces. And so trying to help with the recognition of emotion of others, and also how to, when presented with genuine expression that would generate a kind of a defensive aggression, is to try to learn to moderate and control those emotions. And so there's lots of practicing of interpersonal and problem-solving skills with a therapist-led role play. The therapist can sort of control an avatar and interact, and then finally evaluate the experience as a kind of a debriefing afterward. So this is one example. Another one, there's people looking at domestic violence, and again, theory here about problem of identifying emotion of others. But also deficits in perspective taking, sort of not understanding, but also just not like sort of understanding not just the sort of the facial expression, but also the broader feelings that someone might have in this context. And so not understanding the harm done by domestic violence. And so there's a couple of approaches here. Offenders become the victim. So this is a perspective-taking approach. They are put in a childlike avatar, so everything's changed, so they're smaller, they see things from a different perspective, and they see the interaction, a domestic violence interaction. Or they become a third party, or they inhabit the party who's being approached aggressively in a sort of a domestic violence kind of scenario. And so the idea is to allow for a first-person perspective of a range of things, and then retesting of emotion recognition after the fact. And so there's evidence that some of this kind of works a bit, right? Like it's a bit variable, they're having to fine tune it, but it's suggestive, let's put it that way. Sexual offending, again, so here's a study where the idea was to help with relapse prevention training. So part of sexual offenders against children, the idea is a form of CBT to help people to identify risk scenarios and avoid them and cope with risks and triggers when it's hard to avoid the scenario. And so here we have a VR experience from a first-person perspective of running into children in a supermarket. And it's an interesting paper. They have a bunch of scenarios where the interaction escalates in a way that becomes harder to avoid. The child asks for help. The child is lost. The child asks them to help them get home. And so at each decision point, the person can decide to avoid or to approach. And it includes touching and picking up and all kinds of things. And so the therapist is observing the avoidance or approach behavior. This is a form of risk management, risk assessment. And so this study, quite interesting, they found that in fact, the participants often did not act in VR according to their stated beliefs about the best actions to take in the scenarios. About 90% of the time, they didn't do what they had learned was the appropriate thing to do. And often didn't act according to the coping skills discussed in therapy, and also the therapist's predictions were wrong 25% of the time if they were trying to do the risk assessment just based on sort of normal clinical settings. So kind of interesting, I think. We can have a ton of discussion about, okay, are people managing behavior in this scenario or not managing it in this scenario, in the VR? I'm gonna set that aside for now, although it's an important part of deciding if this is a valid approach, obviously, if we're gonna use it for risk assessment. So another application in sexual offending is that currently under the Sexual Offenders Risk Appraisal Guide, which is a very commonly used forensic risk assessment tool, there's a bunch of characteristics that are scored, and it produces kind of an actuarial assessment of the risk presented by somebody of reoffense. One of those factors is phallometric responding. So phallometrics is a form of measuring arousal, physiological arousal, when presented with various kinds of stimuli. And these can be visual, auditory, can be evaluated through phallometrics. In some places, eye gaze is used just to look at how long people look at particular scenes to diagnose sexual interests as well. So there's lots of ethical challenges and issues with the validity of these approaches, but it is part of the current SORAG to have a score on phallometry. And so what Renaud and others did was they said, you weren't 100% sure about the stimuli, whether they're super valid. Let's try VR presentation of computer-generated images of children. And they found they were superior to the auditory stimuli in generating the response on phallometry. And they suggest that this could be used in assessment as well as relapse prevention to therapeutically understand triggers, develop self-regulation strategies, and so forth. Psychosis. So here we have a context of paranoia and put people through sort of real life scenarios. And the VR was a little bit more persuasive here, I think. But going into a supermarket and having interactions and having a sort of a medium level of crowding, I'm just checking the timing here, yeah. And sort of have them first explore a practice scenario and then go into the actual test scenario, which involves queuing in a line and someone cutting in front and assessing on a bunch of psychometric scales the degree of anxiety and paranoia after each scenario. And so they also had a more sort of, not self-report, but the observation of people's verbal and physical behavior in VR as a way of assessing the presence of paranoid, delusional concerns. And so they found, and so very interesting. So the clinicians were asked about this. This was qualitative. So they asked the participants after, how was this for you? What do you think about it? They asked the clinicians, did you think this was useful? And the clinicians said, hey, this could be a really useful way to establish communication with patients who are suspicious and hostile of psychiatry, will not talk to me, but if they go in there, they will kind of lose track of the fact that we are in a therapeutic kind of context here, and I'll be able to assess and treat. And so what's really interesting about that is it depends upon a kind of therapeutic deception, right? So we'll come back to the therapeutic deception in a moment because it's an interesting ethical legal problem about when and what form of deception is appropriate and consistent with informed consent. And then the other interesting thing is the patients here, they expressed, the authors talk about this as therapeutic misconception, that they were in a research study and felt they were getting therapy, but that's a different ethical problem. For my interest, it's that the patients entering this, they disagreed with their diagnosis. They didn't think there was anything wrong, and they were hopeful that this would be an objective measure proving somehow that the diagnosis was wrong, or conversely, they were afraid that somehow a new psychotic episode would be detected. So I think this is really, these are interesting voices for how people are thinking about what can be concluded from this and how to use it. Finally, avatar therapy. I said a little bit about that already, which was there's an attempt to tailor, have someone describe what they think a persecuting voice would look like. And then they make an avatar of that voice. These are some examples of described by participants in this study, and then interact with that persecuting voice, which is somewhat taken over by the therapist as well with the disguised voice. And this is put in conjunction with cognitive behavioral therapy to try to address the paranoid thinking, and also to try to help people to enter into a dialogue with that voice as a way of attaining better control over it, and so forth, and exposure and responses. Okay, so these are a bunch of examples. So let's turn to some legal issues. I think a first one I'll talk about consent. How does consent work with this when we have a kind of therapy that relies to some extent on a loss of control, loss of attachment to reality. Also, we're in the forensic context where a lot of therapy is offered in a quasi-coercive way. It's basically, everyone knows that at sentencing and later on, if you show yourself to be enthusiastic about treatment, things are going to go much better in terms of parole, in terms of security classification, and so forth. So this is not an unconstrained choice that's being made, and that has important implications also for the kind of therapy that's presented. Second, validity of the risk assessment. We've had some really interesting case law recently about problems of the validity of risk assessment instruments as applied to particular populations. And so I think we have to think a little bit about that, but also think about what if some of these techniques appear to be more valid than the current approach? Does that conversely require the use of something like this? And it's interesting is that if the current approach is under, it's a sort of false negative error, it's not detecting risk, but the improved one will actually be better at detecting risk. It may be that the state and the offender have different interests in terms of shifting to a more accurate risk assessment approach, right? Illegal content, I think, is an extremely interesting question here. Throughout the thinking about virtual reality, we've had this interesting tension between Chandler, who's famous for writing the theory of the extended mind, has moved into thinking about is the virtual reality real or not in a real, almost metaphysical, but also legal sense. If actual real harm happens to people in virtual reality, is that not itself real? We recognize all kinds of intangible forms of harm. And then duty to warn. I want to talk briefly about that too. Let's check where we are. We don't have a lot of time, I'm afraid. I took too much time on some of those explanations. So I'm going to go a little bit quickly because I want to throw out questions and maybe we can follow up with them during the discussion. But patients who initially meet a capacity threshold and consent and are told, we are going to bring you into an immersive world where you might lose yourself. To me, I think that probably is okay. We don't require a continuing ability to consent in the course of treatment. If you're in surgery and anesthetized, you don't wake up to continue your consent, right? So one could say, well, if people lose capacity or attachment to reality in the course of the treatment, is that okay? I ask the question. The whole point is to be present and immersive, is to be detached from the real and enter the virtual. And if you know that there's this deliberate therapeutic deception and knowing self-deception, if you agree, is that okay? And what happens though, because I think that this is not going to be binary yes, no. I think there are going to be cases where you have people who clearly have lost that kind of willing suspension of disbelief and have maybe truly lost contact. And I think harm can be created to people. Trauma can happen. And one has to be careful. So that's one set of questions. Another one is, what about this kind of quasi-coercive consent? And what I would say here is, we do this all the time, quite frankly, with other kinds of therapies. Deacon dealt with someone who was saying, hey, I'm gonna get an inferior sentence if I don't agree to hormone therapy, like chemical castration. And the court said, that's not coercive. You take it or leave it. The sentence is appropriate. So I don't think that the quasi-coerciveness is necessarily a bar here, but should there be limits on the quasi-coercive offers? And there's a lot of discussion in these sort of like biological approaches, like brain stimulation, things like that in the forensic context, that we really have to ask ourselves, what is rehabilitation? Do you speak to the person at the level of reason, as an individual? Or do you attempt to go bypass them and treat them as biological mechanism? And so, I mean, maybe that's a bit of a caricature with chemical castration. You're usually doing both things. You're trying to talk to people, but provide this sort of somatic or biological aid at the same time. But with virtual reality, if you are banking on the person no longer responding with rational sort of understanding of the context in which they're in, is that a reasons responsive approach? Does it cohere with what we think is the appropriate way to do rehabilitation? So should we be treating people in this mechanistic way? What about the validity of the VR risk assessment? So we know from the Corrections and Conditional Release Act that it's incumbent on the CSC, on the system, to take all reasonable steps to be accurate. Furthermore, one of the guiding principles is to have policies, practices respecting differences responsive to needs of all these people and persons requiring mental health care. So we have to be quite careful here in terms of accuracy, but also treating people in ways that responds to their needs and dignity. And we have recent case law dealing with all this. So UART was different. It dealt with these forensic risk assessment tools like SORAG that I talked about recently. And it was a challenge by an Indigenous man saying, this whole thing was normed on a white population. It is not known if it's accurate in application to a subpopulation, a minority group. Now, the reason it's normed on the white population is you need lots of data points, and there's a lot of more white offenders. So that's how the model gets created in that way. There's maybe not enough people in smaller minority groups to create a statistically robust actuarial tool. So you're between a rock and a hard place here. You just abandon ship and not use actuarial approaches for groups within a minority. That might not always be the better approach. So what the Supreme Court said was, well, there's evidence that tools are at least moderately predictive for everybody. And by the way, but the government can still not get away with saying this is fine. It said there was no charter violation, but they said there was a problem with those preceding sections of the CCRA that I talked to you about. You can't do nothing to confirm accuracy and claim you've taken reasonable efforts to confirm accuracy, right? So this means that if these are ever to be used, there's got to be some demonstration of efficacy. But subsequent applications of viewer suggest there's gonna be a lot of room here. Even if you have just modest demonstration of efficacy of these tools, that's all that seems to be required as long as other facts are being considered, including clinical assessment, and that the limitations and weaknesses are noted. So there's this kind of sort of balancing that's happening, and that's acceptable. So Dina, I will just do one more slide. Okay, so I talked about SORAG potentially. VR might be a better way of doing this. Illegal content, and I'll stop with this, and maybe if you want to hear about the other topics, you can ask me in the Q&A. But I'll finish with this one. So I find this kind of interesting. So there's lots of concern in evaluating sexual offenders with the creation of material that itself would offend the child pornography part of the criminal code. If you're presenting stimuli to assess pedophilia, you're at risk of presenting illegal content. So turns out, by the way, the definition in Canada of child pornography, it does not have to be a real image of a real person. It's like written stories, computer-generated material, all of this counts. There is a medical use defense, so you can use what would otherwise be illegal for if it has a legitimate purpose related to, for example, medicine, and two requirements here. It cannot pose an undue risk of harm. So catting back sort of gives us the test on figuring that out. But here we have a question. So what about VR? Legitimate use for medical purpose? I'd say yes, if you're using it to evaluate somebody who has pedophilia and there's an attempt to treat and do risk assessment. But what scenarios are medically legitimate stimuli? That's going to be a constraint on what you do in VR. And the difference between presenting someone with a static image and then measuring response and putting someone into VR to potentially interact with an avatar, there's an interesting difference there. There's an action being taken that itself could constitute an illegal act. If the creation of a depiction of an attack on a child, that is itself illegal, then putting someone into VR in the guise of an avatar that interacts with a child, if recorded, becomes the creation of child pornography. So there's a very interesting crossover between the virtual and the real and the nature of harm and the nature of a criminal offense here. And so that has to be thought about as well. And so the authors said, look, we should, we think this is useful, but we better be careful. Some actions should be impossible, lest they be a form of entrapment of people in the virtual reality. It shouldn't be accessible outside the clinic, only used in the medical context, yes, and definitely not using motion capture of real children. They suggest they're coming from a different jurisdiction with different limitations, but that's a suggestion that they put as well. So I've run out of time, I'm sorry, but I'll stop there.
Okay, thank you to all our panelists. So maybe do all the panelists want to come up, and we'll we have about a half an hour for questions here. If you have a question, you can just step up to the microphone there.
Of data and privacy and how VR can be used and then how that data is captured and how we're, oh no, it's not.
No, it's not turned on, so the people in the stream can't
Oh,
hear
they can't
you.
see. Okay, so my question is about data and privacy and how those images or that interaction is kept, and as well as the implications on whether that is part of the medical record and it should be included in the medical record. So if you can touch on that at all.
Yeah, I did have a slide on privacy in my bloated talk here. Yeah, so I think there's some really interesting privacy implications here. So forensic psychiatry operates in this this weird zone where it has to, there's lots of ethical pitfalls here because the physicians are treating people. There is a therapeutic relationship with those obligations. And yet there's also an obligation to public safety, to the community. And so there's been lots of discussion about how you have to be absolutely candid with the patient about, okay, what hat am I wearing? Am I just assessing you? Am I your treating physician? Am I somehow mixed up in doing both? So yes, I think that if this is an assessment context, that's one thing. I think people need to know that there's not going to be the kind of protection expected. This is being done for a legal purpose. If this is a therapeutic treatment context, then people have to know what the limits on the confidentiality are there. And one that we all know from the Tarasoff case and its application sort of in Canadian context is if there's an identifiable threat to someone in that's being made, like a serious threat to an identifiable individual, then there's an obligation most likely to warn and to break that confidentiality. And so I thank you for the question, because my next slide was going to be, what if you have someone who makes a threat against an individual in VR? How do you interpret that? Is that triggering Tarasoff or not? And how close is that? Do we know the relationship between an action in VR and the risk of acting outside VR? And you can look in the ORB decisions. I had an example of someone whose psychosis, he tried to kill his mother. He had Capgras delusion. He thought that his family had been replaced by aliens, that he actually thought life was a virtual reality matrix scenario. And so if he went into this and they wanted to assess, do you still pose a risk to your mother? Let's put your mother avatar in there. Anyone who tried to kill her, what's your interpretation from that? So there may be this interesting intersection. But I think your other point was, okay, well, we're going to see a lot of behavior of the person in this environment. It might be recorded in the medical record. When could it be used, subpoenaed, used for some purposes? And I think there is a real question there. We have that it might be quite interesting and revelatory information later on, after if a possible crime is being committed, to understand premeditation, to understand behavior. So yeah, definitely.
Thank you so much. My comments and question will be directed to Jennifer again. First of all, it's very mind-blowing and eye-opening, and it's always been reminding me of the play that I studied about in high school, The Imaginary Invalid. So from your presentation, you've answered a lot of legal, policy, and ethical questions. My first question is going to be a realist question of what are the statistics like? What's there available to show how effective this mechanism is, so that we can get out of that box of the imaginary invalid and trying to treat hypochondriacy? Are there tangible results? And then I have a question about ethical and policy considerations, owing to the fact that in the formulation of such literature or in doing the practice related to this, are there questions of cultural appropriateness as we talk about, because different cultures people from different cultures react to things differently. And the question of what is ethically appropriate to a given group of people depends on what their culture is and what their experiences are. In terms of the legal policies, I have a question about torts. There are torts like infliction of mental suffering. What has been the landscape regarding such torts? There are things like triggering and exposure. To what extent does a practitioner distinguish between triggering someone or exposing someone vis-a-vis treating? How do you know what level of exposure to put to someone? And then in terms of policy, this being a new or novel area, what sorts of regulatory frameworks are there? I mean, you may have talked about them, I may be knowing them, but then I just want to hear your perspective on what sort of regulatory areas are there. Thank you so much.
Sure, thank you so much for all those thoughtful questions. I feel like I can't do full justice to them because I should have been taking notes. So on the question of how effective these are, I'm like in the chapter I'm writing, I will review sort of the evidence for these different strategies. I think they're still in development, so some of them seem to show some sorts of effects, partial effects, maybe unintended effects. So it's still, like, jury's out on that. This doesn't seem to be ready largely for prime time. Your second question was, there was the question about inflicting harm. I think, yes, I think exposure therapies, people have to be warned about this, right? They have to be willing to engage in this, and they shouldn't be surprised by what's presented to them, especially in contexts that could be traumatic. But again, I think this is an area where research needs to be done. What are the harmful effects that, like, there's generic problems with virtual reality. People tend to get motion sickness and people can fall over. But in terms of sort of psychological harm, I think this would depend very much on the particular use that's being made, how people are prepared and debriefed and everything. So again, it's hard to give a blanket answer, but I think it's something to think about. We shouldn't be doing iatrogenic harm to people. Regulatory structures for this, I think it's premature. It's not yet sort of out there being used. It's still being developed. That being said, we should think about it before it's out there so that we can hope that no harm is done and that it's beneficial. So maybe we can talk a bit afterward. I think I might have missed one of those questions.
Okay. Are there further questions? If not, maybe oh, sorry, you're behind the pillar there.
Hi. So this is more of a comment, and I'm sorry it's not specifically related to the panel, but thank you very much for all your work. So my name is Marissa. I'm a psychiatrist here in Ottawa, trained at Ottawa U, and I'm really glad to be here. This is a completely different context and just a great learning opportunity. Yeah, I'm not a lawyer. I do not have all of your expertise. So please, yeah, forgive me if I'm speaking mostly in lay terms, but so I wanted to kind of contextualize what I'm going to share. So I don't work in forensics. I do work with some people who are in the forensic system, but not on the forensic unit. I don't work on a unit where there is seclusion, our physical environment is actually more therapeutic than I think a lot of institutions have been in the past. I also want to acknowledge that I'm working in a system that has changed because of all of the work that advocates have done, and patient survivors of psychiatry. System has changed, and there's clearly a lot of room to improve. So I just wanted to provide a perspective that is maybe, speaking where things are not dichotomous. Severity of psychiatric illness is usually on a spectrum, and levels of care, levels of security are probably also on a spectrum. And I just want to present that, there are psychiatrists and there are mental health hospitals or centers that do have a humanistic approach. So I'll just briefly now, just 3 points about involuntary admission. No one likes using the Mental Health Care Act, and it's usually an uncomfortable decision, and I think that it should be. There should always be that tension because it's a tool that carries grave repercussions. And I can only speak for myself, but I'd like to think that I speak for most of my colleagues when I say that we don't take it lightly. And there's usually a very high threshold before we will use a form under the Mental Health Care Act for involuntary admission. And my personal experience in training and working is that it's not used as a punishment. It's reassessed daily. As soon as a person is considered to be, safe enough, we'll discontinue it. And there's usually conversations with colleagues about this. Safety. I wish Archie was still here. I think he headed off. Oh, hi. So, in terms of, safety is always kind of what we have to distill down factors to safety when we're considering either involuntary admission, PRNs, chemical restraints or mechanical restraints. So yes, every person is allowed to access high quality care. Not only the person that might be having acute agitation for whatever reason, but others as well. So co-patients are also allowed to be treated in a safe environment as our staff working there. So number one is always de-escalation, always, and throughout the entire process. Acute agitation can present for many reasons, but when the risk to either the person's safety or others' safety is too great, while still engaging in verbal de-escalation as best as the staff can, sometimes PRNs will be offered, and sometimes patients will ask for them because they know that they need a bit of extra help to help calm themselves down. Chemical restraints, again, necessary only when it's high threshold for safety considerations, and mechanical restraints, last resort. And I just want to, I don't know that it's reassuring, but just sharing that there's very strict policies around mechanical restraints. They are never automatically ordered. There has to be a conversation between staff and the physician, and continuous observation, reassess every 15 minutes. The goal is to discharge in an hour, discontinue it in an hour. And lastly, we always presume a person capable until there is maybe an indication that we have to assess it. And I personally use the U of T aid capacity evaluation. I'll call upon my colleagues in occupational therapy that are often better positioned to assess for capacity. And just lastly, joint decision-making is always part of how I practice and how many of my colleagues practice. So just wanted to present the other end of the spectrum. Thank you.
Thank you. Thanks so much. I'm sorry, I didn't catch what's your name? I didn't catch it.
Marissa
Marissa,
Lepage.
yeah, thank you very much for that. And I think it's important to, hear like a diversity of views on all of this. You said, you started off your remarks with, things have changed a lot and have improved under sort of, pressure often from outside. So, you describe an approach and policy that may be perhaps adopted the majority of the time. How best does one address situations in which that's not happening?
I don't have the answer to that, but I think that it begins in training. So newer generations of trainees are being exposed to more of the social sciences, more humanistic approach, partnership approach. And so, I don't have the answer, but I hope that change will continue to happen, and I hope that people stay angry enough to continue making and advocating for that change. Thank you.
In line with what Jen was saying, I think one of I started off our panel by saying that I love how interdisciplinary these conferences are, and I think that this is the kind of thing that is valuable about it. And lawyers are often going to see different cases than the psychiatrists see, right? And so the cases that get to court, I mean, this is true in all sorts of contexts, but we see the cases where things have gone badly, and if the thing that went badly is in violation of the procedure, well, that's one thing, but sometimes things can go badly in a way that sort of conforms to procedure, and those are moments where I think legal experts get concerned. But of course, we shouldn't overshadow that, you know, there are probably a lot of everyday practices that are perfectly consistent with people's human rights and good values.
I don't want to cut off this discussion if there are other people who want to. I'll let you do that.
Just to conclude, because I'm also a psychiatrist and I have views very similar to Marissa's based on what's been discussed today. But I just wanted to say very often I get patient complaints personally to me about care, and there's an office in the hospital where they can bring those complaints. All physicians are terrified of a college complaint, and those come in large droves. And so there are areas, and there is patient advocacy. So if someone is involuntary, the PPAO do get notified and give the patient rights advice. And so there are other, and I will tell patients to use these avenues generously. And always I'll say, you know, you can even talk to your MP about it or something like that. We also have mandatory M&M rounds. So these are when there is a negative outcome that we know about. We have, they were called morbidity and mortality rounds. So we do hold ourselves accountable the best we can and look at systems issues. And so there are things embedded in place. Of course, if it's very extreme, I think that's where we rely on the legal system to do what it does. But I do think Marissa's voice and the voice of care providers who are really in the trenches dealing with the complexities that you are in theory arguing about in a courtroom, there needs to be a place of safe dialogue with us who are actually in the moment being accountable to so many things that makes it really impossible. So just wanted to say that.
And that's why I'm very grateful to have a psychiatrist in the room, because I think the tenor of a lot of the discussion has come from the legal perspective, has been looking at the abuses and looking at the need to push. It takes an enormous amount of effort to push past the inertia of systems and the inertia of this is the way we do it, and the inertia of we're doing it for the right reasons, therefore it's all okay. So that's perhaps explains the need for this sort of energetic push. But I think that in itself is not going to get us anywhere if we're not talking to the people who are sort of in the system, right? So I'm very grateful to you for being here and being part of the discussion and actually standing up. Takes some braveness to say your piece, you know, in a setting like this. So thank you very much for doing that. And I think it's through this continued discussion and this continued presence at our meetings across discipline that perhaps that this can be eased a little bit. So I want to put that on the table, but I also do want to acknowledge there was a talk on the first day about, well, the PPAO used to be something like this and now it's watered down. Now it's like, here's a sheet with some rights, you know? So there's almost a need to always be on top of that and to continue to push the edges of a system that's underfunded, that's overburdened, that has all these competing duties that it has to recognize. So just a few reflections from my perspective. Sophie.
So my question's for Sylvia, and I don't know if I misheard you, but I wrote down what I thought you said, which was that there's hope that's been recognized as in some ways a legal principle somewhere, somehow, and I was just wondering if you could elaborate on that.
Yeah, absolutely. So the case is Bissonnette. It's another heinous case. I think the Supreme Court case is from 2018, but a lot of you will remember this was a young man who shot up a mosque in Quebec City and killed several people. And so he was, you know, convicted of first-degree murder appropriately. And there was a provision in the code at the time that said that sentences for first-degree murder could be imposed consecutively rather than concurrently, so that his sentence, the judge thought it was appropriate given the, you know, the immense horror of what he had done and the damage that he had inflicted on these families in the community, that his sentence should be consecutive. And so he was sentenced to roughly 150 years before he could be eligible for parole. So most of these people, right, people who commit first-degree murder, first of all, the sentence is a mandatory life sentence. That's the mandatory minimum. And then the only sort of issue is when you might be eligible for parole. So if you commit a first-degree murder, you're eligible for parole after 25 years. So because he had, so they were stacked on. So the point here is that de facto, this guy was being sentenced to life without the possibility of parole. And what the Supreme Court found in that case was that this was a violation of his charter rights, because there should be a right to the possibility of rehabilitation, even for the worst, even for the most monstrous, the most objectionable among us, that there should be a possibility that actually you can make good and change and be a different, he was pretty young, actually. I mean, there's no excusing this murder, but he was a young guy. So they didn't say everybody should be released at some point, but that there should be at least the possibility. And so, in fact, that did enshrine hope as a kind of a fundamental principle guaranteed in Canada, which is an interesting idea and might have interesting applications.
So my question is also for Sylvia and Anoosheh. I'm just sort of wondering about the concept of alexithymia and how that applies in this context, because
you're going to have to tell us what that is.
Yeah, so alexithymia is more of like a personal characteristic, and it's not necessarily a disorder, but it can be seen in people with autism spectrum disorder and depression and across different types of mental health disorders. And so I was just kind of wondering about how that might play into law and these different cases. And if, I was also wondering if you had heard of alexithymia and how does that apply? Okay, yeah. So just curious. Thank you.
Oh, wait, tell us what it is.
So it's an inability to recognize emotions in oneself, but it also translates into challenge recognizing them in other people. And it's not necessarily in the DSM, but it's recognized as like a characteristic that some people have, and it can be seen in some disorders. So I was just curious about that and how it would apply in this context.
Yeah, that's a great. That's super interesting, and thank you for that. I think that one of the many reasons why I was sort of trepidatious about taking on this topic, after I just said, sure, I'll do this, was that
I have the office next door and I made her do it. There's a lot of sort of social issues here, right? And one of them is that autistic people don't commit crimes at a greater rate than the rest of the population. So I certainly wouldn't want to be taken as saying like autism is a criminogenic condition. And even, but I think that this idea that there maybe are certain features that might occur in people across different mental diagnoses, but that might make it more challenging for them to comply with the law. As just Schneider helpfully said, it's not a binary, right? It's not like you're either completely incapable of following the law, or you have all the freedom and agency that anybody would have to decide to break the law or comply with the law, right? There are a lot of people who might have challenges such as substance use disorders or other kinds of bipolar, whatever diagnoses that might make it more challenging for them, and that in some ways it would be nice if the law could recognize that this was a constrained choice. It wasn't a delusion, but it wasn't also like a free and enlightened choice to break the law, right? So yeah, I think there's probably all sorts of like emotional kind of cognition or emotional recognition sort of issues that might make it harder. I mean, one of the things that we didn't bring up but that we've discussed a lot in writing this chapter is sexual assault for people who have a hard time with theory of mind, have a hard time understanding somebody else's emotions. It might be more likely for that person to overstep boundaries because they really don't understand that somebody's body language is saying, get away from me, right? And so without wanting to say like, oh, well, that's fine, right? Because you of course want to consider the rights of other people to exist in the world without being assaulted. But you also might want to have a way of recognizing that this is, not the same type of responsibility.
Yeah, can you hear me?
Yeah.
So the analysis would be, first of all, mental disorder, the presence of mental disorder at the relevant time, at the time of the offense, is a necessary but not a sufficient condition to get you an NCR verdict. The analysis is a bifurcated one. The first is to determine whether the accused at the time of the otherwise criminal act was suffering from a mental disorder, and that's defined in section 2 of the Criminal Code, which is defined as disease of the mind, which imports a vast volume of case law setting out what disease of the mind might be, and it's vast. It doesn't need to be in the DSM, but the first hurdle, though, is satisfying the court that at the relevant time a mental disorder was present. Then the second question is, of course, whether the mental disorder took the accused over the thresholds as described by our first panel, set out in section 16. So yeah, this particular disorder, condition, trait, whatever, is again on a sliding scale, whether it is elevated to the level of disorder or merely a quirky thing that somebody has, that's to be determined by the court, whether that, for this particular individual, it may not be a generic, yeah, ADHD is a mental disorder. It's going to be determined on a case-by-case contextual basis for that individual. So indeed, it may constitute a mental disorder. Whether it's enough to take you over the section 16 hurdles, again, will be determined by the court on a case-by-case basis. But you can't just say, this disorder's in the basket, that one's out.
On that note, we're going to have to wrap up the panel, but I think that was a fantastic conversation, and I believe lunch is happening now.